Welcome to the In-Rim Podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Good morning. Today we're discussing raising private capital. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to our Facebook channel, as well as our YouTube channel. We'd appreciate it. We'd love also to have your feedback, your comments. What you have really helps us know how to push the show forward, know what kind of questions we need to answer. With that, we're going to go to Sean, who's in our studio for our legal update.
Thank you, Andy. So today I want to talk about a recent development in South Carolina involving the Real Estate Commission there. The Real Estate Commission publishes regular bulletins with updates on the practice of real estate in South Carolina, with advisories as to how the commissioner is going to interpret the South Carolina statutory code. And in the most recent bulletin, the commissioner addressed wholesaling and the interplay between wholesaling and the need for a real estate license. And basically, the commissioner, or the Real Estate Commission, went through and analyzed what a wholesale transaction is in relation to what a broker would do. And the conclusion was a little troubling for real estate investors, especially those that are engaging in wholesaling. I'm going to read basically right from the bulletin, and it states, and I quote, "If unlicensed individuals are advertising real property interests publicly with the expectation of compensation, the commission has directed that cease and desist orders be issued against those individuals to stop them from engaging in unlicensed practice." So basically, the Real Estate Commission in South Carolina is taking the position that in order for you to wholesale, and so if you're out there marketing your equitable interest, your contract interest in South Carolina, and you expect to be compensated, i.e. an assignment fee, then you are engaging in the unlicensed practice of real estate in South Carolina. The other development or opinion rendered by this bulletin is that it reminded licensees that they are required to have a listing agreement with the legal, so they don't say equitable owner, they say with the legal owner of the property before marketing the property pursuant to South Carolina Code 40-57-135E1. Well, that applies or will affect, potentially, say, novations, or alternatively, where a lot of investors who have a property under contract are going into the MLS and listing their equitable or contract interest on the MLS. And the Real Estate Commission is saying, according to our interpretation of South Carolina law, you can't do that unless the listing agreement is signed by the seller. So the seller would have to sign the listing agreement even for the contractual or equitable interest to be advertised for sale. So that's a fairly big development. Now, understand that the Real Estate Commission is not a court of law. They are not an administrative law judge. They don't have the power to actually render a legal and binding decision on anybody. But the commission is doing is basically saying, this is our understanding and our interpretation of South Carolina law, and we plan to pursue and prosecute cases against those who are listing property or publicly advertising property for sale with the hope of compensation. And at that point, you're fighting, if you're an investor or a wholesaler, you're fighting that complaint, and you're hoping that a administrative law judge or court would have a different interpretation of South Carolina law. So it's an interesting development. It's consistent with what we're seeing right across the nation. Our very first episode or show dealt with law in Arizona requiring certain closures by wholesale within their purchase contracts, and explaining exactly, their intention with respect to the property, with respect to the contract. And Arizona's one of a number of states that have, over the last couple of years, enacted legislation to try to govern the practice of wholesaling. And South Carolina is following course, except there you don't actually have a legislature that is changing the law or enacting legislation. You have an administrative agency who is, well, we're going to take it upon ourselves to interpret South Carolina law and enforce it with respect to wholesaling.
That seems significantly more aggressive than what we discussed about a few episodes ago in Arizona. What would an investor need to do to challenge that? I mean, if you're challenging the direction of an administrative agency, that's not just a quick thing to deal with.
Yeah, there, at least, for example, here in Arizona, and I'm assuming South Carolina would be similar, there's a couple of options available. One would be to continue practicing or continue to do wholesaling. And if you're charged, go ahead and fight it and try to have an administrative law judge interpret, assuming that the statutes could be interpreted differently, have an administrative law judge interpret it. And the other option is to challenge it right now in court and just say, well, this is what has been published by the commission. And if a group of investors gather together and say, look, this is an administrative decision, or not decision, opinion and advisory, and we want a declaration that, it's inconsistent with South Carolina law. Now, whether or not that can be pursued and is mature and ripe, I don't know. I think the best thing to do is, if you're somebody who wants to wholesale in South Carolina, don't just go and wholesale and then fight the agency. At this point, I would say, first and foremost, go hire an attorney, have that attorney advise you on what the statutes provide. And maybe the attorney looks at it and looks at those statutes and states, yeah, the commission is right. These are what the statutes provide. This is what the cases interpreting the statutes provide. And, unfortunately, wholesaling is off the table in South Carolina without a real estate license. But if you get that contrary interpretation saying, no, the may be wrong, the real estate be wrong, at that point, you have to decide, do you want to fight the agency? And it's a big fight and an expensive fight and a time consuming fight, and would involve a lot of sleepless nights. And it wouldn't be for the faint of heart. Let's just put it that way.
All right. Thank you for the legal update, Sean. The legal landscape of wholesaling is changing across the country, and we'll try to bring you up to speed as we know about it. With that, I want to welcome our guest to the show today, Paul Vincent, attorney and owner of Vincent Esquire, an attorney in Ohio. He's been gracious to be with us, and we're happy to have him. Paul,
hey,
thanks for joining us.
Sean, Andy, thanks for having me on. Flattered someone wants to hear something from me. So that's
yeah, we get excited about that too. When somebody actually cares what we have to say.
Yeah,
right.
It is very strange.
Paul,
thanks for having me on. I just want to add a little bit. The landscaping of the landscape of wholesaling is going to be wholly different. 24 months from now, every state will require a license. And so buckle up, wholesalers everywhere. It's coming. So
For sure. Paul, tell us about what state you're licensed in as an attorney.
So I'm only licensed in the state of Ohio, and we handle a lot of our incoming is SEC compliant. So we help people with the private placement and 506c raises and stuff like that. So we can do that all across the country, and then we help folks with the operating agreements, and we get some local help on that side. But yeah, we're licensed in Ohio. We do a lot of Ohio work, estate planning, kind of entrepreneurial focus in our shop. And then we spend a lot of our time helping people decide what in the world they're doing and raising capital. So
sure. Tell our listeners about Deal Structure School.
Oh, yeah. So I have a private Facebook group with my brother, and we just aim to educate people on the various types of ways to take down both real estate and, business. It's if you wanted to buy a business, we could do it that way too. So we help people with a lot of the, day-to-day speak of real estate deals. A lot of people don't understand, really what title insurance is for, or what, how you can take something through probate, who's the interested party in a probate case, how seller financing can be structured in a way that makes sense for everybody. So we saw an opportunity there. We do that day to day for all of our clients. And we thought, well, how about being another subscription-based platform for people to sign up for? And we put it together, and it seems to be working out okay. And we think people are learning some stuff too. So,
is there a cost to be part of that group?
Yep. Yeah. So it's $97 a month. Anybody that's interested in spending more time hearing about subject to and syndication and, any type of real estate transaction, we do calls twice a week live, help kind of navigate people with their questions, point them in the right direction. And then, and a lot of folks just, if you're looking to get into a mentorship or, whatever you want to call it, mastermind or whatever people are most comfortable calling it, the hardest part is just kind of getting started. So we see ours as the biggest help to somebody that has wholesaled a lot of deals, but are now realizing, hey, I don't want to be on this wheel forever. Maybe I need to figure out, how can I seller finance? What is subject to, and there's a lot of education out there in that space. And, we just figured why not see what we can do to help people out. And it's been good. I think we have, 60 some members in there and growing a little bit every week. So it's been good. We enjoy it.
Cool. Paul, tell us how you got into raising private capital.
Yeah, so I opened up my shop, just me and my brother. We opened it up in 2016, and we with tax liens. Our client bought 600 or 800 tax liens in the state of Ohio. You buy them bulk here. So when we did that, we're like, what the hell? We didn't know what that. Am I allowed to swear on this? Probably not. I won't swear.
Yeah, no, we've had it happen before. It's
okay.
It's
well,
fine.
it won't be. I'll be mindful of it, so it'll be less. So when we signed up for our shop, we didn't even know what a tax lien was. It was a buddy of ours that was running a bunch of them in a separate county south of where we are. And I just kind of been passing, was like, hey buddy, my mother hugged me too much, and I'm confident enough to open up my own shop someday. So I was like, if you get something, let me know. And as it happened, 3 or so months later, they had successfully purchased a batch up in Summit County, which is in the northern part of Ohio. And he's like, hey, you guys want to do it? And, Adam and I thought about it for about 15 minutes, and we're like, yeah, let's do it. So I go onto that long rambled mess there to kind of, that's where we started to see, like, hey, real estate has a lot of ways that you can do interesting things with. So we did that. So we started having a little reputation about doing some real estate stuff when we opened up our shop. And another local syndicator who's in the education space too, I met him, I was bothering him for coffee one day and, trying to figure out how I can be of value to him. And he's like, hey, you want to do a PPM for me? And I was like, I don't know what the hell that is. And this is about, I think 4 or 5 years ago. And I had no idea what it was, but I was like, but I'm going to help you because you don't know what it is. And at least I can get into the door to a lawyer that does know. And then I was like, I'll just help you shepherd through. So it was just basically me just trying to, be helpful to a person that was way further ahead on the success ladder than me. And I happened to call a shop out in Utah that does it and has done it for 25 years. he answered the phone. I was like, this is weird. Anyway, and we hit it off. And then he was kind of a mentor to me for, you know, a handful of deals. And then from there, I just started doing it on my own. But yeah, just basically heard about it. It was actually at a conference right when we first started too. And someone talked about a PPM. We didn't know what it was. Like, oh, you can do that. You know, we did. We're like most people probably listening had never done it before. And then we did it. And now we do it pretty much for a living. So,
Paul, as attorneys, we take this for granted, but I can't tell you how many times in dealing with raising private capital, I speak with a client and, you know, I hear what they want to do it. And I'm like, well, I think that might be a security. And they're like, well, what is that? And why is that a problem?
Sure.
And I'm like, well, that's a big problem. Something you need to think about. So let's start as we kind of get into private capital. I know you probably deal a lot with that. What is a security?
Yeah, well, the common, you know, just kind of an easy definition is if someone's investing money and they're expecting to get that money repaid either with a return, hopefully, right? That's a security. The four-prong test is an investment of money with a common enterprise, which is doing something with it, right? Like adding to an apartment complex, adding value to an apartment complex, flipping a house, whatever that is. With the expectation of return. So you put $100 in, you're hoping to get at least 100 and something back with that money. And then based on the efforts of somebody else, not you. So if I were to give Sean $100,000 because Sean's going to go buy an apartment complex, I expect Sean to use that money for the purpose of buying the apartment and then giving me some money for the investment. So that's pretty much it. Someone giving you money with the expectation of a return on that money based on somebody else's work, which in this case, it would be Sean's. So that's it. And it's very basic. If people are asking, is this a security? 99 times out of 100, it is a security. And then you should start thinking about like, hey, do I have to worry about SEC compliance? Do I have to call these lawyers up and overpay for what I think they do? And that's pretty much how it goes.
So a loan could be a security then, right? I mean,
yeah,
we talk
for sure.
about
Yep.
hard money loans
Yep.
and things like that. We're talking securities.
Yeah. So, you know, there's some exemptions to having to worry about doing a private placement, you know, and all these offering docs. And there's a couple things. So if you have a mortgage on it, some people think they've figured out, they've beat the SEC and said, hey, I'll just give, you know, 18 people a mortgage on a property and look, I'm exempt. No, that's not going to do it. So you can do it like if I were to give Sean money, Sean can secure my money against a flip, you know, on a single family house or something like that. And that's an exemption, even though it is a security and I'm expecting a profit on that. Since he's able to put a first lien on it, it protects my money, then I'm okay. We don't need to worry about it. The other kind of
now you use the term first. You use the term first lien. So it has to be a first lien.
No, not necessarily, but
okay.
when taking everything, when you're taking everything into consideration, if there's another lien on it, practically speaking, if I were to put the money as a second, it could be a triggering event. So I don't even get into that kind of, you know, area of whether or not to worry about it. So I'm just saying on a typical flip, private money loan, first lien, you're going to be okay. The other exemption to worrying about compliance is the 9-month threshold. So if someone's going to invest money in you and they can get it back in 9 months or less, you don't have to worry about the compliance part either. That's an exemption that the SEC is pleased with. So those are the two. And then if you're going to do anything above that with more than one investor, then we start thinking about, okay, do we need to do, you know, the private placement and the Reg E and all that other stuff. And that's where we kind of help people navigate what to do.
So you mentioned securing the loan by real estate, and out there in the investor world, I know that there's a lot of short-term rental investments, and one of the strategies that investors have used to furnish those rentals is to obtain financing from private investors and to secure that financing by the personal property that's being purchased, you know, via those loans. You know, UCC1 financing statements. Is that considered secured to the point where you have an exemption, or would that be a security at that point, assume that it's longer than 9 months?
Yeah, so I would say it's for sure a security, right? It's someone, given that with the expectation of profit. The thing is practically speaking, how many people are investing in that, right? So if it's only one person given either the bridge or whatever it is to close that loan, do you have to worry about it? That you're not going to probably get any, and of course there's the legal asterisk. You may, of course, but no one from the SEC is going to come knocking on the door for, a securitized furnishing on a single, on a short-term rental in Cleveland or something like that. So you're probably going to be okay, but it really comes down to, if I'm raising money, how do I make sure as best I can that these people are secured with their money? If you're not going to worry about any of the SEC compliance, and if you have one investor, you're going to be fine. You don't need to really worry about it. And the idea is that you're not ruining the future of anyone else except this one person. And hopefully, you're doing a good enough job not blowing that money. Because if you're just blowing the money, then you have other things to worry about, like conversion or, theft or something like that. So.
What about a membership interest in a limited liability company?
Yeah, so that's basically what everyone is selling when you see stuff splashed all over the internet of, hey, I got this great deal in Phoenix. It's a 506c offering. That's really what you're selling. You're selling membership units. So there's a LLC pie made of 100 slices, and you're selling off pieces of that pie, and that is the membership interest of that LLC. So every commercial deal of any sort of significant size requires a single purpose entity or a special purpose entity, whatever you want to call it. That LLC will be the property owner, and then that LLC will be made up of a number of people, active members, people that are working on the deal, making sure that it's being renovated, making sure that it's performing, and then inactive members or passive members, and those are people that are just investing money with the expectation of return. And those varying members will own certain pieces of that LLC depending on what your offering is. So if it's $1 million raise, let's say it's a $3 million property and you need $1 million to close it, you're going to sell 100 units, and then you give out proportionate equity however you want, and that's all over the place. And we could do a full show on slicing up deals that way. It just gets confusing, a lot of math, bad math probably, but yeah, that's all you're doing is selling membership interest. And when you do that, then we got to worry about the SEC, and that's what we do.
What if it's just, hey, I found a good property. I know Paul Vincent. I need a little bit of capital. It's a good opportunity. And I go and say, hey, Paul, we know each other. How about you come on board and, I'll give you a 30% interest in this LLC, and we'll do this deal together in Phoenix here. Is that something where I now need to do a bunch of security documents for you as a minority investor in the LLC?
Yeah. So if it's just one person, I think you're going to be okay. And this isn't being recorded, right? So no one can.
It is being recorded.
Yeah, no, I know. I'm just kidding. No, practically speaking, you'll be fine. You're going to write in there, you're going to secure that person. Is it a security? Yeah, it is. I mean, it is.
Right.
But if it's a $40,000 investment, you don't want to be spending anywhere from $10,000 to $60,000, whatever some of these shops are asking for, to do that, right? So yeah, if you're doing a onesie investor, you should be able to manage that relationship well enough and be able to, you're both fiduciaries together with that venture, where you're going to be okay. So now, if you ask an SEC agent, they would probably be like, yeah, you got to do all that, but hopefully none of them are on Facebook Live. So.
Well, my big takeaway is pretty much anytime you're receiving money, or you're joint venturing, or you're doing anything with anybody else, it's a security. And really the question then becomes, what compliance and what kind of, disclosures and documents do you need to,
That's exactly
provide?
Right. Yeah, and it's tough baseball for a lot of deals that are really tight anyway, to have to imagine, putting another 10 to, like I said, the range for syndication is really anywhere from about 10 to up to like 50,000, depending on the fanciness of the office of your law firm. but then it becomes a risk thing. It's like, well, as long as this deal goes well, no one's going to know that I didn't do this. And this is what I find surprising, is that banks aren't requiring this sort of thing to close these big loans, because, if you have a private placement, or you have an investor without a private placement and they're like, hey, I want my money back. It's been 6 months. Now I'm going to raise hell because I don't remember you telling me this is going to be a 3-year hold. Like, if I'm a bank, that puts the whole deal at risk, right? If they go, sounding the alarms at their state or federal SEC, you can have deals go sideways pretty quick. So at some point in the near term, unfortunately for investors, fortunately for me and you folks, I think the banks are going to start requiring to make it, almost like, hey, was your operating agreement? They're going to be like, hey, do you guys have a private offering doc that we can look at to make sure everybody's on the same page? So
tell us about promoters. What is a promoter for purposes of securities law?
Yeah, so that's someone that is out trying to sell the security. It's usually the quarterback, maybe the biggest partner of the deal, the person with the most either skin in the game or equity in the game. So basically the person that's, going to be the managing member. That's someone that's selling this offering to either the public, if it's a C, the one that you can advertise everywhere, or to the pre-existing relationship folks on a 506B. So it's basically the quarterback of the project, the person that's going to be signing the loan, the person that's going to be selling these securities to potential investors.
So at what point does that quarterback, in the eyes of the SEC, become the promoter?
I would say once it's under contract and it's like, okay, now we're really going to close this thing. So you can have a bunch, it doesn't just need to be one person as a promoter. It can be anybody. Like if us three went in on a deal and we're all selling it to our own network, or we're all pitching it, on our own channels or whatever that might look like, we would all be considered that person probably in the eyes of the SEC. So one of the things you got to worry about is whoever is pitching this deal, what's their background? Have they ever been in trouble before, criminally or, civilly or that sort of thing? So yeah, but there's not a real bright line for a lot of this SEC stuff. Like, what is a pre-existing substantive relationship? Oh, I don't know. Depends who you ask. There's a few bright lines, like what's accredited investor and stuff. But outside of that, there's no bright line on a trigger.
Well, what is an accredited investor?
Cool. Yeah. So that is a person that makes $200,000 a year with the expectation that's going to continue into the future. So you can't just have it one big sale, right? You sell one great year of roofing and now you're an accredited investor, but then next year you stop working. So it's someone that makes $200,000 a year or $300,000 with a spouse or a spousal equivalent. So that's kind of a new development there. With the expectation that it's going to happen, into the future. So that's one version of it. And the other version of it is if you have $1 million of net value. So whatever your assets are, less liabilities, if you have $1 million left at the end for yourself individually or with your spouse or spousal equivalent, then that's an accredited investor. So
when do you need to confirm whether somebody's an accredited investor?
Prior to the deal closing, and really you should have it before they wire off any money, save yourself the trouble. So let's say I'm doing a 506C, which is the one that you can advertise to the crowd, right? And the other nuance to that is that I can only take money from an accredited investor on a 506C. So if I send this to Andy and Sean, who are the richest guys on this podcast, and I can send them my private placement. They get to look at the thing. They get to review it. And they're like, okay, I really want in on the deal. That's when I would be like, okay, now before you sign the subscription agreement, I want you to prove to me that you're an accredited investor. And it's on me, the guy quarterbacking the deal, to ensure that these folks are accredited. And then there's a couple ways of doing that. I always tell people there's 3 ways. First, go to verifyinvestor.com. It's a third-party website. It covers me, because they have to upload all their stuff. If they falsify it, it's very reasonable for me to rely on this very successful website's version of whether this person's accredited. If they doctor up the docs and it comes back later they're not, that's not on me. That's on them for lying. And I was reasonable in relying on verifyinvestor.com. The other version is you have them get their financial advisor or accountant or lawyer to sign off a letter that they're an accredited investor based on the guidelines. That doesn't happen very often because professional service providers don't really know, and they don't want to spend the time to do it and don't want to put their own neck out there. Super wealthy people have these like brokerages and shops that'll do that. But, regular folks typically can't get their accountant to even get their taxes done on time, let alone write a accredited investor letter for you. And then the third version is for me to actually review your W-2 or to look at your assets, and you send me your tax return and stuff like that. That one, it's probably 50-50 between a verified investor and then me as the person looking at it and confirming is what I see. I always tell people, like, send them off third party. That's simplest and safest. But if you have a 79-year-old investor, they don't really want to go on the web and put their info in there.
So it's critical that this is fleshed out before the deal closes.
Yeah. And it happens. It happens after the fact, but you're not supposed to. You're supposed to exchange that information. You verify, then they wire the money, then that money gets used and encumbered into the deal and all that. So. How
often do you get clients that come in and say, "Hey, I'm just thinking about this deal. What do I need to do to start it?" Or is it more often the case that we've been talking, we're ready to pull the trigger, have this ready by 5 tonight?
Yeah. So it's nice so in this market, you guys have probably seen too, like everybody can be a real estate something like after a weekend, right? There's so much access on the internet, so many conferences, so many exciting things and exciting ways to learn. So we get a lot of like, hey, I got this thing under LOI, or I think I'm going to get under LOI. And then, we have a couple-minute conversation about the timeline of things. We just tell people right out of the gate, if they're calling us and they're like, hey, we need a placement like in 2 days, we're like, well, good luck. Like we're relationship guys. So if someone's, I feel, being unreasonable or being kind of a jerk right out of the gate, like I just am like, you should go somewhere else. So thankfully we get it early on. We like to know when it goes under PSA, and then we can start on our side. It usually takes us about 2 weeks to get our stuff turned around. And a lot of it relies on the promoter knowing what they want to actually sell, because most people don't. They're kind of like, hey, well, what do you think? And then we just kind of shepherd them through the different things they can do. So,
are there different groups or places that an investor can go to find accredited investors? Meaning, I know if I recruit somebody from this particular arena, that they're likely going to be an accredited investor, or do they just have to go out there and try to figure it out on their own?
So there's certain websites, right, that you can use to kind of crowdfund some of these things. I think Equity Door is one that comes to mind. But people are really investing in the person as much as they are in the deal. So it's like, it's like Andy's network is going to be, would invest with Andy. But if my deal is even better than Andy's, it's very unlikely they're just going to be like, it looks like such a great return. Like most people aren't investing unless they find the person already credible, or they get credibility from somebody else, like someone else is invested in a deal. So, there's some websites or like groups like, Family Office Club is one that I think of that, it's really good. They have great stuff, tons of information, contact information. The problem is if people don't know you, they don't like you or trust you yet, they're not going to give you the money anyway. So you got to unfortunately put in the hard work, either by being out there on social media and talking about what you're doing, so you can build credibility that way, have a podcast, that sort of thing, so they can feel like they at least know you a little. But just, my clients don't generally go and just try to fund it online to like a website. They use their private network, or they use their network's network, or the other active members in the deal to help raise the money for it. But yeah, it's I wish there was an easy button. There's not one yet, at least not that I've heard of.
Tell us about the private placement memorandum.
It's a real snooze fest of a legal document, basically just disclosing all the risks of real estate. It says, 100 different ways, 100 different places that there's no guarantee in real estate. There's a significant amount of risk in any investment, but it just goes through all the disclosures of a real estate transaction. So, hey, it's, we're going to be like, for example, now every private placement since COVID, we now have this pandemic disclosure in there that, wasn't in there before. We never had at least in our stuff, we had, acts of God, right? If our place gets bowled over or bulldozed by a tornado, that's in there, but nothing, we didn't have anything about, epidemic, pandemic stuff. So just discloses everything about the deal, the sources and uses, which is like, okay, if we're taking in $1 million of capital, what are we going to do with that? We're gonna add a building. We're gonna add some more pads if it's a mobile home park. We're gonna renovate the bathrooms and the kitchens of the 100-unit building. So it describes that. It describes the debt that's going to be on it. The terms of that debt. Just everything and anything that an investor would like to know gets described in there, and then all the big risks of investing in anything is in there too. So that's really all it is, a disclosure document to tell investors, hey, you got to know this is not a sure thing. Basically discourages people from investing, really.
So if an investment requires a private placement memorandum, does it also require an accredited investor, or are those things mutually exclusive?
Yeah, so you do a PPM for 506B, which is accredited and unaccredited investors, but then that can only be advertised to those pre-existing relationships. So I couldn't pitch you two on a 506B because I don't know you guys yet. I don't know anything about your investment background. I don't know anything about your family or whatever. We don't have a pre-existing relationship. So the PPM would only be able to go to people that I already know, or active members of my deal, people that they already know. So there's that. And then we would do, if we did a 506C, which is the one that we can advertise to the crowd or the community, that's kind of how I remember. B for buds and blood, people that you know, or family, which are, I guess, the same thing. And C is for the crowd. Those are the two ways that I kind of describe it to people. And if it's a C, then I can advertise to you too, and I would send you the PPM you look at, and if you're comfortable with it, then you can come aboard. But I can only take accredited investors. On a B, they can be both accredited and unaccredited, up to 35 unaccredited investors. And then, but I do have to know those investors before I send them the stuff.
But both of those require private placement memorandums.
That's right. Yep.
Okay.
A 506C, technically you don't, the SEC doesn't require that, but it would be silly not to put it together, So we do all of them. We actually don't tell anybody that, because then everyone's like, well, why do we do it? Can I save like a couple $1,000? Like, no, you can't. Or you can just go somewhere else. So
Right.
Tell us about, this will help future investors think about this early on in the deal, but tell us about the consequences for violating securities laws.
Yeah. So, if it turns out that someone either alleges and or proves or whatever the hell the outcome is, and you haven't done one of these disclosure docs, you're not going to probably be able to ever do this again. If there's a rescission event, they're going to require that you repay everybody the money. Well, what if the money is like tied up in real estate? Well, any shortfall, it's coming out of your pocket. You'll never be able to escape that. And then, there's obviously jail, if you really, and that wouldn't happen. I guess I can't say it wouldn't happen, but it'd be very unlikely if I just was an honest person that had a deal completely go south and everyone lost their money. That's probably not like a prison situation because I wasn't stealing. But if it turns out that the government thinks you defrauded people because you didn't disclose to them that, oh, by the way, the title came back and this property was on an active volcano and it blew up and now the property's gone and it's not insured, so that sort of thing. But the downside of not doing this disclosure documents is you're not allowed to do any more capital raising. You're going to be considered now a bad actor. So if you're a bad actor, you can't own up to 20%, more than 20% of a deal. And like I said, civil and potentially criminal fines and or jail if you're really bad. If you guys want some entertaining stuff, go to sec.gov and get the updates. You'll get people like, a Tom Smith that the most brash one that I saw was a guy, financial advisor, took $200K from a client out of their brokerage account, bought himself some super high-end car, and then he resold that car to that same person he stole it from. Like, what a nightmare. And that guy, of course, was going to prison, and he's probably still there. But, generally people that have bad deals, it's because bad underwriting, bad construction cost, that sort of thing, not stealing from the cookie jar.
Now, we've talked about the SEC, which is federal, but there's also state securities laws. At least I know here in Arizona there are. I'm assuming, it's pretty common throughout the country. Talk to us a little bit about the state laws and what you've seen as far as, how they might compare and contrast to the federal requirements.
Yeah, so they basically all fall. So they have their own agencies, like in Ohio, there's the Ohio Securities and Exchange Commission, same thing. It's basically just another governing body to check on things, So if in the state of Ohio, there's certain states that every time somebody files a blue sky, which is basically a filing to this online database that says, hey, I'm raising capital in these states, and you pay a filing fee for each of those states. And it's basically just notifying those state securities and exchange commissions that you're raising money from an investor in their state. And some states, when they get that, they send a letter off and say, hey, I see that you've raised some money, from a resident. Tell us more about your deal. They want to know, like, hey, was there an acquisition fee? Was there a commission made? And if there was, and if you answer yes, of course, they're going to be like, okay, cool. Show me somebody's, license that allows for you to make a commission. So yeah, every state is subordinate to the federal law on this stuff, but they also do some of their own policing. They're also there if the deal goes sideways, they can be contacted and be like, hey, something suspicious is happening about my investment. Can you look into it? And those agency employees will come knocking and check in on you. So
I've heard the term prospectus used at times in talking about securities. Is that the same as a private placement memorandum?
Sort of. So prospectus is like a public offering. It's stuff you got to file with the SEC. In private offerings, so stuff that we could raise capital for, that's basically like your offering memo, like, a pitch deck or something like that an investor. So a prospectus in the public sphere gets it off the internet and looks at it, decides whether or not they want to buy, someone's stock, Facebook stock, or, Google or something like that. In our world, it's like, hey, here's our pitch deck. These are some of the projected returns. This is what we're going to do on the money. And it's not as formal as the SEC prospectus, but it's a good common name that people, use in the private offering space too.
So a prospectus primarily is dealing with, publicly traded corporations and stock. Okay.
Yeah, the technical prospectus is a real term used for, pulling down the financial information every quarter from Facebook or, one of the big shops that are on one of the exchanges.
Now, you mentioned a blue sky registry or registration. When does that have to take place?
It's within 15 days of the money being used. Essentially, it's 15 days after your first sale, but the timeline of these deals are sometimes different. So somebody may invest money early on, but the money's not truly encumbered yet because it hasn't been closed. So we say the sooner of 15 days after you take the money or when it closes. We do often, the close date because the money can all be refunded until it actually closes. So,
you mentioned, or you were talking about the penalties involved with the violation of securities laws. And obviously, everybody agrees that, these bad actors ought to face, serious penalties. But so often, in my experience, and I think you suggested the same, so often these investors fall into it inadvertently. They don't even have really a concept that there's this federal law that they even have to deal with.
Totally.
They know that these big publicly traded companies, are highly regulated, but me, just Joe Schmo pushing a real estate deal. What does that matter? Is there, so it like I said, in I see a lot of folks that just kind of fall into this inadvertently.
Mhm.
Are there a set of factors or things that the average real estate investor should be thinking about on the front end that might suggest to them or trigger, hey, I need to look at this?
Yeah, I mean, so one thing I think people accidentally fall into it is this difference between a preferred return and a guaranteed return, right? So it's like, hey, if you put 100,000 in my deal, we're going to pay a 9% preferred return. So you kind of, I think, as a person that's putting the deal together, the promoter, like if someone's like, oh, is this money guaranteed? I bet 8 out of 10 times people say, yes, it's a guarantee. It's of course not a guarantee because maybe you don't always hit that. So that to me is kind of the biggest potential fraud is and where people get themselves in trouble is language like that. If someone, reaches out or asks a question during the webinar or sends an email off and say, hey, how is my money secured? And they write back and say, yeah, well, it's, you get a guaranteed 9% return. And then, you own membership interest in an LLC, which there's no guarantee. So if you're the person that's investing and you don't get your preferred return for a year or two or more, depending on how bad the deal's going, you could obviously say to the SEC and say, hey, I feel like this guy's ripping me off because he said I get this 9%, but I've never seen it. And then the SEC is going to come in and be like, hey, show me the emails. And then the emails say what we've discussed, and they get themselves into trouble. So kind of a very easy thing to remember is any sort of fact about any active member in the deal. Is there anything in your past that if you were an investor in the deal that you would want to know? Things like, have you filed bankruptcy? Have you had any foreclosures filed? People hate to disclose that in these things, but it's like you need to disclose it early and often, because if somebody comes after the fact, they can use that as a way to kind of say like, hey, you never told me that you had a foreclosure in 2003 or a bankruptcy in 2002, 20 years ago. And they could just say that, hey, I wouldn't have invested had I known. And then they get the fraud trigger and somebody's upset and wants their money back. And now they call the state, SEC and stuff. And this, thankfully, knock on wood, this doesn't happen very often. And a lot of it comes down to communication. That is, I guess that's one thing for anyone thinking about raising money. How comfortable are you talking to people about money and the deal? And if you're not, then you probably shouldn't be doing it, because that's all you're really going to be doing when you're raising money is talking to people about the deal.
Paul, you mentioned that part of deal structure school is talking about creative financing subject to some seller feedback. Now, we've identified that pretty much any loan is going to be a security. What about seller carryback financing? Are there any concerns there, and any type of disclosures and documents that are required in that context?
Yeah, I mean, I think the biggest disclosure problem I see for people is just not being honest about what's happening on like a subject to or something like that. Is, most people enter into these things and they haven't told the seller like, hey, this debt's still encumbered against your name. So, just know that, and it's an uncomfortable thing because you don't, if you're a seller, sometimes they're like, well, then why would I do that? Why wouldn't I just try to sell it or whatever? But no, we don't, on a subject to, there's only one investor. So it's not anything that I think, if it was a seller finance for, $1 million, I guess, why wouldn't you? Because you've already, you're doing it with other people. So make sure they're kind of involved in that process. But yeah, you'd be okay under that scenario.
So if the seller takes a, $300,000 second, to make the transaction go through, there's not a PPM or anything that would have to go to the seller to basically say, hey, if this property depreciates, you could end up losing your money type of thing.
Yeah, I mean, that like kind of one of those risk, kind of questions. Is it a loan for more than 9 months? Is this person going to have it? Yes, but then it's like, well, do I want to go pay a lawyer to do this and spend that money? It really comes down to the person. We have people all the time that are like, hey, I need to raise $100,000 and I'm probably going to get it from 3 or 4 people. And we tell them like, yeah, it's a security. You should definitely do the private placement. Now we leave it up to them. And do they want to spend the money? And then they usually do the mental gymnastics of, well, it's, I probably don't really need to. And, we tell them like, well, you need to, but if you don't want to, that's on you. You get in trouble, not me. So.
Mm-hmm.
Just backing up to your last point about disclosure, are you suggesting, or do you suggest as a best practice for a promoter or somebody pulling together a deal who does have some background, whether it's a bankruptcy or something to that effect, or anything else that you, if it were you, the one investing, would want to know? Do you just go through the disclosure process no matter what? Just follow the SEC requirements, regardless of whether it's on the edge of being a security? Just do it, just as a best practice.
Yeah. So if someone, if somebody as a 19-year-old, had a theft from Gap or something like that, it's like, well, let's just put it in there. And a lot of times people don't really, if you have in the real estate game, if you're a big real estate tycoon, you filed bankruptcy at some point.
Sure.
It's just a numbers game. If you do a number of transactions, something's going to happen at some point. So, it's a little section of a 100-page document. If somebody sees it, they'll actually feel way better about it than if they didn't. We've gotten, we have a couple clients that we park that in there, and we've gotten calls from people like, hey, what do you think about this? What's this bankruptcy? And, and then the person just says like, yeah, I had 18 houses, in 2008 that I had lending on and nobody was paying me. So we had to discharge all the deficiencies and, that's that. So, yeah, I mean, anything concerning dishonesty, you want to make sure, bankruptcies, you want to make sure to disclose, I'm sure there's been foreclosures that have not, come to my desk that people don't, never found out about, but it's best to be open and obvious about any potential, gripe someone would have.
Sure. Well, Paul, we really appreciate you being with us today. Super informative. Fun. I think it's a great topic. It's an important one for real estate investors, and in my experience, ones that they just don't seem to think about until they get to a law office. So we really appreciate your time, and thanks for being with us.
Yeah, no, thanks so much for having me, guys. Appreciate it. And one little nugget for people: if you're underwriting a deal, and not everybody costs $20,000-$30,000 to do a placement. That's not it. But if you can't pay those fees, then the deal's too tight. Don't do it. So that's kind of the only thing I'd say in passing. If you can't afford just the closing fees are expensive. So if the deal can't cover, now banks are charging so much, $70,000 in closing, it's not worth doing. So,
Paul, where can our listeners find you?
Any of the social media stuff, Facebook is good. And then vincentesquire.com. My email is paul@vincentesq.com. And just happy to help anybody kind of get started, any seasoned vets, any brand newbies. I do a lot of discouraging day to day, so I'm happy to continue to do that.
And is there a place that they can go to find out more about Deal Structure School?
Yeah, so it's Deal Structure. I can't even say it. It's Deal Structure School Crew on Facebook. So if you type that in, you can say you're interested, and then I can tell you what it's about. And if you're interested, of course, you're welcome to join.
Awesome. Well, thanks so much for being with us. We'll see you next time, Paul.
Thanks, guys.
Thank you, Paul.
All right, everybody. That is our show today. Next week's episode is litigating title claims. On that show, we have guest attorney Nicholas Strom, who will be with us talking about his experience in litigating those title claims. Thanks so much, everybody. We'll see you next week.